Welcome, friends. Welcome to Simzuu. Now, friends, we have seen 2 episodes on medical certificate. This is the third one. Now, in this episode, we are only going to see cases as far as medical certificates are concerned. In the earlier episode, we already saw certificate by an allopath and a Vaidya and a quack and an RMP and all of those things, whether it is necessary, nomenclature, malingering, everything. Those of you all who have not seen the earlier episodes, I would request that you first, it's a chronology, it's a sequence. So you first see the episode number 1 for medical certificates, then 2, and this is the third one wherein we are going to just consider cases. Cases, friends, is now in Somabai Rambai versus Himabai Mills. It was held by the court that non-attachment of the medical certificate would give rise to some suspicion. There is a thing in law which is called as onus. The burden of proof is on the one who alleges. I say I am sick, so who has to prove? I have to prove. There is a maxim at common law, affirmandi, non-negandi, incumbit probatio. The burden of proof is on the one who alleges, not on the one who denies. If I take up a stand that I am sick, I am producing the medical certificate, then genuineness is presumed and the management suspects it. So management, non-attachment of a medical certificate. If I don't attach, then naturally anybody would be suspicious. Now friends, the second case, Manik Singh Surjit Singh versus Harilal Manufacturing Company. If the management is not given an opportunity only to consider the medical certificate, it cannot be used later. That is, the workman comes up and he says, I am ill for 3 months and no medical certificate and nothing, and the management ultimately takes an action on the basis of this, but you have not produced a medical certificate. Conducts an inquiry, terminates him, and later maybe in court he brings. So maybe he is very well within his rights to produce any document, but then whether the action of the management which was based on the non-giving of the medical certificate, question is whether that is right or whether that is wrong. And this case says no, the action of the management was right. Now, P. Talaiva MGR Transport versus Industrial Tribunal is another case. In this, the medical certificate is to be produced before the leave and not at the time of resumption of duties. Now, this is very important. As I told you, some workmen are funny. Somebody will send an SMS. Everybody's got a mobile phone. Somebody will call on phone, I'm not coming today. That's no way of taking a leave. And if you are sick, the medical certificate has to be given in advance at the earliest stage. He cannot give it at the point of resumption of duties. No. Where were you? How were you absent? And moreover, you have put the management in an handicapped position. Why? Because how would management conclude to give you sick leave or not when there is no medical certificate? And you are going to give it at the point of resumption of duties. That's not allowed. And in Associated Cement Company versus Cement Workers Union, it was held that asking of a medical certificate from a qualified doctor for 1 day leave is unnecessary. For 1 day leave, when the management says you are one day leave, come on, go to a qualified doctor, give a medical certificate. It's a minor ailment. Hardship to the employee is to be seen. You are here to help the employees. You are not here to exploit employees. You are not to, squeeze the juice out of them. Every management, it should have, the motto should be to help employees only. We here stand for employees. And medical certificate is necessary. Sometimes management accuse somebody that you are producing medical certificate just to prolong the illness and this and that. This will be a question of fact. It cannot be answered in a yes and no. Every case is different, you have to see. Then in another case, Chipping and Printing Employee Association versus Zambre. This is another case where in the medical certificate it was said that should be produced in the original and not a Xerox copy. People there are so many scientists in India, and some of them use that scientific knowledge somewhere else. Just mix 3 Xerox copies and make a 4th one and then say this is mine. So the disease is his, hospital is something else, and then the name is mine and this is mine. No, original has to be produced, and Needless to tell you, friends, under the Indian Evidence Act 1872, production of the original is considered as a primary piece of evidence and the Xerox copy would be a secondary piece of evidence. What the courts would insist is, or at least in this case, what was insisted is the primary piece of evidence, that is the original copy. Now, friends, in another case, Upper India Sugar Mills versus its employees. It was held that the non-production of medical certificate by a practicing doctor can be fatal to the workman. He should be a practicing doctor. He should be a doctor first and foremost, and then he should be practicing medicine. And his medical certificate, if it's from a fake doctor, needless to tell you that such medical certificates will not be entertained, not only by the management but by the court of law also. So this is very important. Then we go to the next case, that is Ram Surat Singh versus May and Baker. But this also is a case on medical certificates, wherein one is to expect that the medical certificate, if at all, should be from an allopathic doctor only. Courts say this would amount to discrimination. No. We saw it in the earlier episode. An authorized doctor, may it be a Vaidya or a Unani person or say allopathy or homeopathy or anybody, if he is authorized to practice, he is an authorized doctor, then you have to believe him. So the management cannot just do something to disbelieve him. And then you insist that no, the certificate has to be from an allopathic doctor only, MBBS and MD. No. In fact, court went the other way, that it would amount to discrimination. And this is not a proper way of functioning also. Now, in another case, Daulat Singh versus State of Rajasthan, it was held that an employee produced a medical certificate. And then the management found out that at the same time he was attending some law classes also. Now, two questions arise. The certificate is false. And what about the doctor? He is given a false certificate. And in such circumstances, the certificate can be discarded. And then, of course, for giving false certificates is a serious misconduct for which a departmental inquiry can be held. Of course, in accordance with the principles of natural justice, and the employee could be terminated also. Now, in another case, that is Hard Motor Transport Limited versus Kanaiyalal. Proving of any illness depends on the evidence, and the medical certificates here plays a role. Court or the management is no judge to say that he is suffering from this thing. Medically, I am saying. As far as medically a person, anything you have to opine, as far as his health is concerned, the medical certificate comes to the fore. And medical certificate will have to be relied as far as only his health. Whether it's a bona fide or a genuine one, courts can decide. Friend, in another case, that is British India Corporation versus Workmen, the company sent its medical officer. It's a huge company. It has its own dispensary medical officer. And it has sent its medical doctor to examine that employee. It was held. Nothing wrong, because what the medical doctor is doing, the medical doctor who belongs to the company, what he is doing is he is finding out malingering. Malingering, again at the cost of repetition, friends, I tell you, malingering means pretending to be ill. And under that pretext you take a leave. There are many who do it. And then in Yashwant Rone versus Goodless Wall Limited, where a medical certificate was refused by the employer without sufficient reason. Some people are, very autocratic in their approach. Some have a narcissus complex, that is self-love. He thinks he is the most brilliant, most intelligent person on earth, no end of himself. You produce any certificate from an FRCS doctor or an MD or an MBBS, he looks at it and throws away. No, not acceptable. Who are you? How can you not accept a medical certificate given by an authorized doctor? And if he does so, this sort of an autocratic behavior, that would be nothing but arbitrariness, which would be shut down. And then it would be quashed by the courts. And lastly, the last case, friends, we are going to see, that is Canara Bank Staff Union versus Union of India, wherein here the bank got the employee examined by a doctor, and then the point came, who is going to pay the fee? Now, it is at the behest of the management that the bank employee was sent to be examined by a private doctor of the bank. The court said that yes, in this case, the management has to pay the fee because you cannot expect him to pay the fee. So what we see is that in all of these cases, the thread, as far as medical science is concerned, health-wise medical certificates to be relied upon. And then we saw so many shades. Of course, this is not all in all. Time is also limited. These are a few cases. And I hope you enjoyed all the 3 episodes on medical certificates. We'll come up with something else now, because in our journey of knowledge sharing, we always believe that knowledge prospers all. Lastly, friends, again, those who have not seen the earlier episodes, I would request them to see. Again, we'll be on the same platform. Knowledge prospers all. Thank you, friends. Thank you.